Hello, yes, so welcome to the latest in our Hempsons webinars series. My name is Robert McCartney. I'm an associate here at the firm and I specialise in general practice and part of the corporate commercial team. Today we thought we'd kind of invite our colleagues from the employment law team to give us a bit of an update on a couple of the areas that have changed recently, and also to have a little bit of a kind of future gazing exercise of looking at what the new government might bring in for us. Okay, so on that basis, I'm just going to hand over to Rachel to introduce herself.
Thanks, Robert. Hi, everyone. I'm Rachel, a solicitor in the employment team here at Hempsons. In the employment team, we tend to work across all sectors, doing all types of different work, so litigation or corporate support. Generally, employment, as we'll see today, is a sort of mix of case law that we see through come through tribunals, and also policy changes. So we're going to be covering a bit of both today, and a bit of an update, things that might be helpful for you to know in sort of day to day. So the topics that we're going to cover today, firstly, heat of the moment, dismissals and resignations. So obviously, we like to think everything's going to go smoothly, but sometimes tensions arise, especially in the workplace, and people react quickly. It's about how to deal with those sort of more erratic conversations, what your obligations are, and how to sort of manage those situations if and when they do arise. We'll then talk about recent changes to the flexible working request rules. So this is a new ACAS code of practice. It came in April, 6th of April this year, but there's not been a lot of talk about it, and we're finding that quite a lot of employers aren't aware of the changes. So I just thought it would be helpful to run through a summary of where those changes are and what your new obligations are. And then, as Robert said, just a bit of a summary. We'll do a whistle-stop tour through Labour's proposed changes. There's been a lot of talk about proposed changes, but as yet it's unclear, obviously, the exact details of what they are, but it's helpful to know what might be around the corner for businesses and employers. As Robert said, we'll do Q&As at the end, so please do send in any requests or comments. So firstly, heat of the moment, resignations and dismissals. So as with anything, there can be situations where things get a bit heated and things are said quickly. When we say heat of the moment, we are not talking about a specific legal definition, but it's essentially as it's understood in everyday life. So where words are spoken in an argument or a particularly stressful time, for example, an altercation, it's often an impulsive decision. And sometimes, as we'll see with this, it can be regretted, and that's where sort of issues can arise. We typically talk about resignations because that tends to be the more common situation with a heat of the moment sort of decision, but it does apply equally to dismissal. So everything we talk about today is also applicable to dismissals in the same way as it is to resignations. So the reason that it's come up more recently, as with everything in employment law, a lot of the legal basis comes from tribunal decisions. So this was a recent case that was heard in the Employment Appeal Tribunal, which is the step above the Employment Tribunal and the step below the Court of Appeal. So the Employment Appeal Tribunal decisions are binding, which is why it's always really helpful when a decision comes through them, because their judgments will be binding on the lower tribunals. And so in this case, an employee resigned in the heat of the moment following an altercation with their manager. They resigned during that argument, and they had done the same thing previously on actually several occasions. And on those previous occasions, he had been persuaded back into his role, an understanding of that it was heat of the moment, and they wanted him back. So that had been done. This time, again, he changed his mind and he wanted to retract his resignation. But this time his manager refused and decided that he didn't want him back. He then made a claim to the Employment Tribunal on the basis of unfair and wrongful dismissal. So he said that it shouldn't have been taken seriously. He didn't really resign. It was heat of the moment. He claimed that there were special circumstances surrounding what he had said and why he had said it. It went through the original Employment Tribunal. They found against the employee, so they found that he had resigned. It was a proper resignation, and they dismissed his claims in the tribunal. He then appealed to the Employment Appeal Tribunal, and he was successful on the basis that the appeal tribunal held that the original tribunal hadn't actually considered the correct test. So they didn't decide the matter, but they sent it back down to the original tribunal, which is one of the options that they have on appeal, to basically rehear the case again, but applying the right test. So we don't actually know yet, as far as I'm aware, what happened in the reheard case down in the tribunal. But the important thing was that the Employment Appeal Tribunal, when it was considering its decision, had a really helpful discussion and consideration of heat of the moment resignations and how they should be applied in the law and how employers should be considering them. So that's why this case is really important and interesting, not because it was successful at appeal or not because of the way that the Employment Tribunal is going to rehear it, but actually because of the discussions that were happening in the Appeal Tribunal hearing. So what is the law? The basic position is that once a notice of resignation has been given, it can't be unilaterally retracted. So that means that whoever gives that notice, whether it be dismissal or resignation, can't decide that they take it back. So that's the sort of starting position. The only time that they would be able to do that is if the other party agrees. So as we saw with that case, in the previous resignations, both parties agreed that they were happy for that notice to be retracted, and therefore all was fine and they all carried on. There's a couple of common misconceptions about notices. One of them being that notice isn't valid until it's been accepted. So, for example, if you hand in a resignation and then receive confirmation of that is the point that the notice is valid, that's not true. The notice, once the notice is given, that's it. And linked to that is another misconception that maybe an employer could refuse to accept a notice or sort of question that notice. That's again not the case, because once you give the notice, that is the end of the matter. So again, the giver of the notice can't change their mind unless the other party agrees. And in OMAR, that's why, which is the case in the EAT, that's why the employer needed to agree to that retraction of the heat of the moment resignation. But we'll see as we go through the case that each case will be totally individual and it will turn on its individual facts, which is always the way, frustratingly sometimes, in employment cases. So that is the sort of basic legal principle that we sort of have as a starting point before going into the discussions. So the Appeal Tribunal commentary, sorry about all of the words on the screen, but I thought it might be helpful to have them there. The commentary was that when it's given verbally, words of dismissal or resignation should be construed objectively from the perspective of the reasonable bystander viewing the matter from the employer's perspective, and should be construed in all of the circumstances of the case. The circumstances that might be taken into account include absolutely anything that was readily available to the parties that would have affected the way in which the language used would have been understood by a reasonable bystander. So where an employee resigns, that means the relevant perspective is that of the employer who hears the words of resignation. So it doesn't matter if someone off the street, how someone off the street would understand the words, but the test is going to be if a person in the shoes of that employer at that time heard those words, would they understand those words to be a resignation or a dismissal? Another point that the EAT covered, which was brought by the claimant in this case, he claimed that there were some special circumstances that meant that he should not be, his resignation shouldn't be taken seriously. That was debunked by the EAT. There's no such thing as special circumstances in the question of whether there's been a dismissal or resignation, and how those words should be construed. What matters is the test on the previous slide. So the reasonable person standing in the shoes of the employer. What must be apparent to that person is that the resignation or dismissal was seriously meant, really intended, or conscious and rational. So that means that the speaker of the words genuinely intended to resign or to dismiss someone, and that they were in the right mind of doing so. But that doesn't mean that you have to agree with them or think that this decision is sensible. You can come to a conscious, intended, seriously meant decision that everyone else disagrees with, and it doesn't mean that that decision was not conscious, rational, really intended, and seriously meant. So that's one of the main points. Not to conflate the two, I suppose. In the vast majority of cases, this is from the EAT, where words are used that objectively constitute words of dismissal or resignation, there'll be no doubt that they're really intended, and in essence, the analysis will stop. But where that's not clear, for example, where one of the parties involved raises a query about, retracting that statement, or such as in this case, decides that they don't want to rely on it, that's where these additional tests will come into play. So if you do find yourself in a situation where you're having to decide whether to rely on a resignation or a dismissal that happened in the heat of the moment, these are some things that to have a look at in terms of evidence if you are coming to that point of having to question whether there was a real resignation. So you'd want to look at the wider facts around the resignation, what the context was, although bearing in mind that what matters is the words. What were the actual words that were used? Are the facts that surround that situation relevant to what was said? And is there can you objectively show an intention to answer that sort of really intended question? It's worth noting that all of these apply to written notices, but obviously it's far more rare to find a situation where a written notice is disputed, just because ideally they're not being sent in sort of the heat of the moment. You're much more likely to find this around a sort of verbal notice, words that are said without really thinking, rather than an email or a letter. But it is worth noting that the same rules do apply to written notices. So some points to note in terms of how we take this case law and the commentary from the EAT and how we apply it into sort of general everyday situations. Number one, try to avoid heat of the moment dismissals. Obviously, you can't control as an employer what employees say, but it's slightly, hopefully, easier to control a little bit more about what staff are saying, managers are saying to staff, for example, or just in general, making sure that there are less opportunities for these sort of rash, quick altercations. It's not saying that they can be avoided entirely, just in the same way that resignations can't be avoided entirely. Heat of the moment dismissals do happen. But yeah, if it's avoidable, then it is best to avoid it. If something does happen, so say a verbal altercation where someone resigns, or the other way around, someone is dismissed, keep sort of documentary evidence of what's happened, write it down, what was understood in a situation, have a note of the meeting, have a note of someone who was there, what they recollect, how the words were taken, what words were said, that kind of thing. It just really helps to be able to rely on that later down the line if it does become challenged. For resignations, this is on the basis that you are accepting the resignation. Follow it up in writing. That's good practice anyway, but particularly in these cases where things are done quickly, it's worth following up in writing, confirming the position. We'd always recommend sort of confirming last days, notice periods, all of those things, just again to have that paper trail to rely on if you need to. And finally, just a reminder that neither party who's given a notice can unilaterally revoke or reject that notice, whether that's dismissal or resignation. And so if you are in a position where it's being given, you need to proceed on that basis, taking into account, obviously, that test that we've just discussed in terms of what you should be considering and how to confirm that. But yeah, once a notice has been given, the main rule is that there is no requirement to accept it. There's no opportunity to reject it. Once it's been given, if it's a valid notice, then that's the end of the story.
And so, Rachel, I'll just take this opportunity before we move on to the next topic, just to ask a couple of questions that's been to my mind. And in particular, one of the things that I was thinking is you say there's no obligation to accept, so it's still binding. But could there be a scenario in which you think, I don't believe that employee meant that? I think many of us have been in a situation, particularly, I think for those of us who've got background managing healthcare services, high stress environments, moments where people get angry, get upset, and say, I'm quitting, I'm leaving, whatever it happens to be. As an employer, is there any kind of duty or obligation to say, actually, is that a resignation, or should you be doing anything to kind of assess that position at that stage?
Well, I think part of it depends on your position. If you're, in this case, the one that ended up in the EAT, they didn't want to retract that resignation. They wanted to accept it as a resignation, and therefore it was important to establish the meaning behind the words. I think if you're worried that someone didn't mean it, it's worth having an open conversation. If your position is more neutral about whether if they turn around and say, I didn't mean it, whether you would want that, it's worth considering. So it's worth considering the employer's position first, but having an open conversation and your understanding of what had happened, just to confirm it, would not do any harm, because either way it will help understand the context and the intention, which helps with this test set out by the EAT. So I think if there's any doubt, it's worth having an open and honest conversation about what the conversation was and whether it's truly meant.
Yeah. And another query that comes to mind is if there was as this applies to dismissals as well.
Yeah.
If you've got a hierarchy of management within your team, within your practice, and you discover that one of your managers may have, for want of a better term, sacked somebody in the heat of the moment, and you're not happy that they followed due process, and you're really concerned about it, what steps do you think should be taken in that kind of situation?
Well, yeah, I mean, ultimately that opens up a real risk, depending on the length of service, to an unfair dismissal claim, because if the employee can turn around and say that was a dismissal, then the employer will most likely be found to have dismissed that employee, never mind whether it was a manager acting roguely or not. So I think, again, open conversation, if you're not happy with the decision, you can have an open conversation with the employee saying, we don't want to, we would like to retract the decision, we would like to forget about what happened and have you back. Ultimately, it will be, if it was a valid notice, then it will be up to the employee to agree to that. And if they don't agree, then you may be stuck with having had a dismissal that you didn't mean. And
when you say valid notice, would that need to be in accordance with, say, the terms of their employment or a policy, or could that be overridden by the words or actions of one of your managers?
Yeah, so valid notice in this situation would be more in line with the test. So were the words meant, were the words, so you couldn't have, for example, a defence saying, I dismissed you, but actually, according to your contract, it needs to be in writing, so therefore it's not valid. So based on this test, if there was sort of context and there was rational intention, then that would override that.
Okay, great, thank you. Should we move to the next topic?
Yes. So The next topic is the recent updates to flexible working requests. So this is based on, it stems from an act, the Employment Relations Flexible Working Act 2023, which came into force on the 6th of April 2024, so this year. It includes a new ACAS code of practice on flexible working. So ACAS is an independent public body, as I'm sure you're all aware. It's sponsored by the UK government. So it's sort of linked with the government, but it's not part of the law in legislation, as it were. There was I think it was an ACAS survey fairly recently that found that 7 out of 10 employees are currently unaware of the new rules, and 43% of employers. So it's obviously an area that has sort of passed people by a little bit, which is worrying in the sense that there's new obligations. So it's important to understand where those new obligations are, because they've been in force actually since April. So before going into what's new, it might be helpful to go through the previous position, which you may or may not be fairly aware of, depending on how many requests you've actually had in the past. All employees had the right to request flexible working after they reach 26 weeks of employment. So once they've been somewhere 6 months, they can request a flexible working sort of amendment to their contract. Employees can make one flexible working request per 12-month period. And they were required to set out, as part of that request, the impact on the business and how that might be mitigated, and what they would suggest in terms of making sure that the impact was lessened on the business. Employers then had 3 months to consider a request and make a decision. And they were given 8 different grounds to deny a request, which we will cover a bit later. So the new position, these are the changes that have come in since April. The right to flexible working, instead of being 6 months down the line, is a day one right. So someone could be hired and the next day make a request, and that would be fine. There no longer is a need for employees to present a business case, as it were, so a sort of summary of the potential adverse impact of their request and how they might mitigate that. Instead of one request, it's 2 requests now per 12-month period. Instead of 3 months to make a decision, employers have 2 months, and that does include any appeal process if it's needed. There's a new requirement to consult directly with employees, which wasn't in the old requirements, and also no change to the 8 grounds on which you can refuse the request. So the changes are more to the process rather than the basis of the decision. But as you can see, there's quite a lot of extra things being added in, so that the requirements consult and the lessening of the time to make a decision. So those are the main changes. These are the 8 grounds. So just as a reminder, because as I said, these haven't changed. There's 8 different grounds in which you can refuse the decision. If we go through them, the burden of additional costs, and I should say some of these will be much more relevant to certain industries and some of them will be relevant to others. There's no sort of hierarchy in terms of the grounds, but it will just depend on how you work, what the request is, and the impact of that request as to which ground might be more relevant to that situation. So we've got burden of additional costs. For example, if you'd have to hire again by accepting the request, or you might have to pay overtime to other employees to facilitate the flexible working, then that would fall under this. An inability to reorganize work amongst existing staff. So, for example, if the person making the request is a particularly skilled worker, or they have a quite specific job, and that's not possible to reorganize without significant difficulty, then it would fall under that. Inability to recruit additional staff. So again, depending on the request, it might not be possible to recruit staff to cover the time or the days. I don't know, if someone has requested to leave at 3 every day, you can't necessarily recruit someone if you need to cover 3 till 5 or whatever the remainder of that day is. So that would fall under that. Detrimental impact on quality of work. So taking a GP surgery, for example, if a receptionist wished to work 2 days a week, this could have a detrimental impact on the quality of the service, or the impact, for example, on patients trying to access care. That kind of example might be relevant there. A detrimental impact on performance. So if granting the request has a significant impact on this person's ability to carry out their own role, then that would be falling under this. Detrimental effect on the ability to meet customer demand. I mean, obviously, in this, if you were talking about GP surgery, replace the word customer with patient, and that's sort of self-explanatory. Insufficient work for the period employee proposes to work. So this is where sort of a difference in workplace or sector comes in. For example, it might be a restaurant worker or a bar worker who says, I only want to work on Mondays and Tuesdays, which are obviously going to be quiet days for the business. So they may be able to reject that request on that basis. And finally, number 8, plan structural change to the business. So if you are currently going through a restructure or redundancy, that would be a valid reason for refusal. So just a whistle-stop tour of those sort of 8 grounds before we get into the process. So what is an ACAS code of practice? It was first introduced in 2014, obviously updated this year to reflect these new rules. It's not a legally binding document, ACAS code of practice, but it is considered by tribunals. So they'll often consider ACAS codes when they're considering how employers have dealt with situations or requests. And in that sense, not following a code, it can be on things like disciplinary grievance or here flexible working. It could count against an employer if it's examined by the tribunal down the line with certain impacts on things like compensation. So this new code will do a sort of brief whistle-stop tour of what it covers. It's and sort of the general principles behind it. So they're suggesting, or it's included, to keep an open mind. This is actually in the forward, so it's not actually in the code itself, but it's important as it urges employers to be constructive, keep an open mind, and it suggests a starting point of considering what might be possible rather than a sort of automatic no, you'll have to persuade me otherwise view. This is one of the most important ones, having a clear policy and procedure. So essentially it needs to be, it's helpful for everyone. It makes it clear to employees what information they need to provide. It makes it clear to employers what procedure they need to follow. And it obviously is very helpful should things be challenged down the line. So yeah, mentioned it already, I think, but the number of live requests is still 1. There's been a change to the number of requests that can be made in a 12-month period, but actually you can't make them both at the same time. For example, there can only be 1 live request per employee at any one time. So as we'll cover shortly, it's going to be increasingly important to make sure that your record keeping is up to date, because it will be very hard to know with an increase in amount of requests how many live requests that person has at one time without having some focus on how those are recorded. Reasonable adjustments. Failure to make a reasonable adjustment is a claim in itself, and flexible working could be a feasible reasonable adjustment. So when there is an employee with a protected characteristic of disability, that is going to be a particular consideration, because not only is there a potential failure to abide by the ACAS code for flexible working, but it may feed in, and we'll cover these sort of concurrent claim points in a moment, but it may feed into other claims like discrimination or a failure to make reasonable adjustment claim, which have uncapped damages, as you may or may not know already. So it also provides some information about accepting, rejecting requests and appealing those decisions. So if you accept the request, this should be confirmed in writing. The employee should be offered the chance for a discussion to clarify any helpful information, and how things might work in practice going forwards, how it's actually going to work, that kind of thing. It's really helpful to have that confirmed. Even if you're completely accepting their proposal, we love a paper trail. So we always say, just confirm everything in writing. You've got something to refer to and look back on if you ever need it. If you're rejecting a request, it's before this code, you would have been able to reject it with a reason, as long as it falls within those 8. Now there's a need for a consultation before any decision is made. So there's some guidance on what that consultation might be. It's encouraged to be something like a face-to-face meeting, or basically any process where both sides of the table essentially can come together and have a discussion, rather than it just being done on paper. And appealing a decision. So there's no right to an appeal, but employers are encouraged to allow an appeal process if they are minded to reject a request for flexible working. But again, there's no statutory right for that. It's just encouraged. So along with the code, those are sort of the main, I'd say, bullet points. And the code goes into a lot more detail as to each one, and with lots more explanations on how they should work. But alongside the code, ACAS has also published some non-statutory guidance, which is more sort of contextual information that just might help employers, or they feel might help employers who are dealing with these requests, because obviously they can be quite varied, and sort of how to manage the process. So some things that the guidance covers are some examples of different types of flexible working. So as you can see, there's a lot of different types nowadays, with people requesting flexible working for all sorts of different reasons. As it said in the sort of beginning of the code, it's all about considering what might be possible, not coming at it from a sort of rigid perspective. And all of these are ways that jobs can be varied in a way that really may not have an impact on the output. So they should all be considered. How to agree flexible working, both formally and informally. So it has some guidance for employers there on sort of what processes should be followed, and maybe some tips on how to manage those meetings. Dealing with changes related to a disability. So we discussed that just a bit before. That's a really important one, because a rejection of a flexible working request could well lead into a claim for something like failure to make reasonable adjustments. So it's really, really important to consider those particular requests very carefully. It covers some practical considerations about making and considering requests, advice on communicating a decision, and what to do next, including handling appeals, and also goes into a bit of the benefits of having a flexible working policy and training line managers so that everyone is aware of their responsibilities. So it's a sort of overarching guidance note, but it's actually probably very helpful in terms of if you are faced with this situation, where to go for some pointers on process. So what can happen if you are not following this code properly, and someone, for example, makes a flexible working request, it's rejected, and they are disputing that decision? So there is a standalone employment tribunal claim. The normal time limits apply. So an employee who's making a claim to an employment tribunal in pretty much any capacity must issue a claim within 3 months of the date that they rely on as the event. It's expensive to defend a tribunal case for employers. There are no costs to an employee to start a claim. If they choose to, they could be unrepresented throughout and therefore not incur any cost. Whereas for the employer, there's a lot more responsibility, there's a lot more obligation in terms of disclosure. All of those kind of things fall to the employer a lot more often. So there's a cost to that. And employment tribunals are cost neutral. So there's also no cost recovery if you are involved in a case. If a case does go to the employment tribunal, they could order the employer to reconsider the request, and they can also order compensation of up to 8 weeks' pay for the employee. So essentially what could happen is you end up going through a tribunal case to be told to reconsider the request that should have been considered in the first place, and you're sort of back to square one, but with a bill and a compensation payment. So that would be very frustrating. But importantly, there's also a link with other claims. So we discussed it on disability. There's a link with failure to make reasonable adjustments. It could be a failure in itself to not consider flexible working properly, but it also could form part of a chain of failures. So that can just basically add on to another claim and making other claims a lot more substantial. Another relevant one that comes up is indirect discrimination, and that could be for a variety of reasons as well as disability. So it's really important to understand the reason for the request. So for example, if someone's making a request for flexible working in order that they can go to a religious building to pray at a certain time and observe their religion, then to refuse the request unreasonably could be indirect discrimination because it's linked to their protected characteristic of religion. There's lots of examples. So it's really important to understand the basis of a request as well as the impact that it'll have on the business, because all of that will come together as to whether it was reasonable in the circumstances to deny the request. So it's definitely worth considering for those reasons. Those discrimination, both of those cases, failure to make reasonable adjustments and indirect discrimination, have uncapped compensation. So they can be really substantial, particularly if this flexible working element forms part of a more long-standing claim or a more serious claim. So again, that was sort of whistle-stop tour, but what are some tips for employers to note and practical outcomes? Important to remember that even with these changes, there is no automatic right to flexible working. What it's changed is the process and some additional obligations on employers. We'd recommend you update policies to reflect this updated legal position, or at least review policies and make sure that they're in line, and ensure that requests are dealt with in a way that's compliant with this new law and the new code. As I said before, there's tons of guidance. It's really helpful. And so if you are faced with these kind of situations, make sure you are looking at that guidance and understanding your position and your responsibilities before taking the action. Consider what your consultation process is within your business. It might be that with this updated guidance, you might want to make some changes, for example, having mandatory meetings or ensuring that there is a consultation process that you think fits with your requirements. And also consider whether your record keeping procedures are sufficient and whether they might need to be strengthened. For example, how will you know how many requests have been made within a 12-month period? And how will you know what consultation has taken place now that those are much more at the forefront of your obligations? So a little review of your current practices and also going forwards is probably going to be helpful. If you are seeing more requests, then the resources will be slightly more stretched. And so it's worth having these practices in place before you know, even if you're not having requests now, before you potentially do receive more of them. So that would be our advice, just to sort of be prepared and make sure you know where to look when you do face that situation.
Thank you for that, Rachel. Before we move on to the next topic, when we were discussing this, there was an interesting nuance that I think would be applicable for many of the attendees on this call. This new act, correct me if I'm wrong, is only applicable for employees.
Yeah.
Is that correct? So where you're in a partnership, it isn't directly applicable as for the partners.
Yeah, no, it's not. So it applies to employees, but I suppose the important note is that discrimination is a claim that can be made against partners.
So discrimination and failure to make reasonable adjustments if there's a potential disability.
Yeah.
Both of them could in theory impact, well, there are definitely claims that partners can bring against other partners.
Yeah.
And a request for flexible working within the partnership could in theory therefore be used as evidence against one of them if it's...
It could, exactly. So the ACAS code wouldn't apply to that request, but that request could, if it was rejected, be a failure to make reasonable adjustments. And so it's worth, I think, considering the code as a general position that the law is happy with, even if you're working within a partnership because of the basis of a disability discrimination claim.
Because ultimately those claims would be brought in a tribunal.
Exactly.
And a tribunal naturally would go, well, we're aware of all this guidance over here, and they might not actually be aware that's not directly applicable to partnerships.
That's it. And also if they're going to apply it for employees, then it's probably the standard that they would expect as well for other sort of working relationships. So it's definitely a good go-to guidance, even if you're not strictly bound by it in the position that you're in.
Great, thank you. So we're going to move on to the kind of gazing into the future of what the current government's like to say. We're going to try to knock through this as a bit of a whistle-stop approach to give enough time for a couple of questions at the end. But again, please let us know if there's any particular topic you'd like us to kind of discuss further.
Yeah. All right. So, as you said, these are all proposals. There's not a lot of detail on them, but it's where the intention is. Not clear yet which, if any, and which ones will be implemented and how they will be implemented. But as I said, it's really good to know what is potentially coming. So day one rights. So this is relevant to flexible working as well. That's just been changed to a day one right with a previous 6-month qualifying period. Labour would like to make the right not to be unfairly dismissed a day one right. You may already be aware that there's currently a 2-year qualifying period for that one. So that has a potentially really big impact, particularly on things like managing probation, managing recruitment. If that right comes in as a day one right, then a lot of that protection for employers will fall away. The right to parental leave, that's currently got, some of them have a 1-year qualifying period, and that is proposed to be removed. So again, that would be day one change. 2 is on fire and rehires. It's constantly in the news, fire and rehire, because it's so unpopular, but it is used fairly regularly, particularly in sort of big restructures. Labour is planning to bring it in only to bring in a requirement that it's only permitted as part of a business restructure, where it's necessary for the business to remain viable and also where there's no genuine alternative available. So it's going to be more about justifying the use rather than it being an option that's available, albeit unpopular as it is at the moment.
So hopefully with that one, I mean, it's not something we see too commonly in healthcare.
No.
Although it have seen it in kind of councils have certainly used that approach sometimes in the past.
Yeah.
I guess one of the key points of that is there are established ways of assessing this. From using kind of principles from other parts of employment law, such as the ETO reasons, economic, technological, organisational. Could they potentially be applied here? Yeah,
it's not clear, as I said, how it's going to come into play, but it could be something like that they'll bring in a test or a bracket within which it's a reasonable decision to make. It's going to be about businesses having the requirement to consider that rather than as it is at the moment, sort of just go for it and see what happens.
Okay. Yeah.
So 3 is a proposed amendment or change to the 0 hours contract provisions. So the suggestion is that all workers will have the right to a contract which reflects the number of hours regularly worked based on a 12-week reference period. It's not clear. I mean, this comes from 0 hours contracts being seen as sort of exploitative. So it's not clear whether all 0 hours contracts will be banned on that basis or whether it will only apply to contracts that are considered exploitative, and not clear how that would be distinguished because, and we were having this discussion the other day, some of them actually are quite beneficial to workers. And so there is a distinction. That's why it's always very difficult to rule around 0 hours contracts because they are easily exploited, but when they work very well. So really unclear how that one's going to play out, but I can see the basis behind it.
I think there's definitely a power dynamic here, which often comes up in employment law, looking at where the balance of powers actually sit. Because often zero-hour contracts can be used for senior roles to reflect the fact that they don't want to be working there all the time. They've got other opportunities, other career choices.
Yeah.
But also we do see it being used in an exploitative position.
Yeah, and I think a lot of the media attention is on the exploitative position, whereas actually they're actually used a lot more regularly than you'd expect for all sorts of roles, as you say, going all the way up to very senior roles. So yeah.
With that, just taking that one forward one bit, because it's probably, we don't know when these might be brought in, but the government is so large now, they've got such a large majority, they could bring them in fairly quickly. This may be one of those topics to preempt that if you are using 0 hours contracts, give them a review, consider whether or not it's now time to move over to a different form of kind of contracting your staff. And if it's not, then that might be an area where you think, actually, we feel these are suitable. And at least you've got a baseline for whenever the legislation might come out and guidance with it, at least you can respond to it quickly.
Yeah, I think that's a really good idea, because often businesses will fall into the habit of using a particular type of contract, and it's never really considered again whether it is the most appropriate type. For example, if a business has evolved or changed, or they've hired more people, or hired people in a different way. So it's certainly always one to keep on review. Is this the most appropriate way to hire this person or engage them? So you'd be disappointed to hear there's another proposed change to flexible working, but actually, hopefully not a change to the process. It is, well, actually, it's going to be a change to the process if it comes in. This may, it's question whether the recent changes in April might have preempted any further changes. So this may not be one that they take forward, but the proposal is that flexible working to be the default if requested from day one, unless it's not reasonably feasible to accommodate. So instead of having the 8 grounds for rejecting, it will be sort of flipped over to say it'll be accepted unless it's not reasonably feasible. Again, really unclear how it's going to be put into practice if it is. And as I said, it may be that actually now that they're in government, they may feel that those changes in April were more than sufficient for sort of protecting employee rights, and focus on other ones, because as we've seen so far, there's a fair amount of proposals going on. This one is a little bit more long term, so they're looking at employment status and they're looking at more long term reform to streamline the current system. If you've had experience with a sort of dispute or worries about employment status, you will know how the complicated nature of having 3-tier system. So particularly in relation to worker and employee, it can be really, really hard in practice when you come to a dispute to sort of work out where someone sits in that scale and what that means. So it probably will be very helpful to have a 2-tier system of, as it's proposed, to have employed or self-employed. Having said that, it would affect almost everything involved in working relationships, and so it would need a hell of a lot of work to get it to a place where it makes things easier rather than harder in the short term. So we'll see where they come to in terms of proposals. It impacts things like employment status, impact almost everything in terms of employment, but also things in terms of tax. So that would be a real overhaul, and it won't be coming in without a lot of consultation and sort of proposal, understanding what's going to happen before it happens.
I think, having said that, it would be nice to clarify, particularly that gap between worker and
certainly
and employed positions.
Yeah, it's really difficult to work it out sometimes. So I think it would, if it's a proposal that makes sense, then I personally think it would be very helpful, but it has to make sense. And then finally, there's some proposed changes to the employment tribunal procedures. So currently, almost every claim is sort of 3-month time limit for presenting that claim to the employment tribunal. They're proposing increasing that to 6 months. And along with the increase in day one rights, it's likely this is going to increase the number of claims brought. But the tribunal, if you've got any tribunal cases on, or you've had them on recently in the last couple of years, you'll know that we can be waiting, 1 year, 18 months for a first hearing at the moment. So I don't know how the funding or the resourcing would be obtained to sort of support all these extra cases, but that is the plan.
I think from this one of the interesting bits is, as an employer, you often get into a position where you think, okay, we've got 3 months and then we're free.
yeah, the danger zone.
But the flip side of it is employees then rush in to put in very quick applications that may not be as fully structured as they might be, and that can lead to some complications. So potentially a 6-month window might give a bit of period to negotiate better settlements and to avoid them. Tribunals as well.
No, absolutely, it could be a beneficial thing for mediation. I mean, we see cases quite regularly where we're making quite good progress in terms of resolving a dispute, and the deadline comes up for an ET claim, so it gets put in, and that sort of inflames matters because you have to then take a more litigious approach. So actually, having 6 months may well, for some situations, be really helpful. It just, as you say, you have that period that you're in danger for a claim, and that period just becomes longer. So those are the 6 sort of main points that I think would be relevant. Obviously, if as and when any of them come in, there will be far more understanding and knowledge about what they entail for employers. Does the law differ with the number of employees in an establishment? No, not for this. There are some laws that affect bigger and smaller employers differently, but no, not for this. This is the law, depending, no matter what, basically.
So if anybody does want to contact us and ask any further questions or like any support on implementing any of the changes that have been recommended, we've got a feedback form on one side, and here's the contact details. Here you go. Feel free to reach out, and we will be able to respond to any queries you might have. I think kind of takeaway points would definitely be looking at your policies and procedures related to kind of dismissals and resignations, and most importantly, flexible working. But as always, if you have any other kind of queries, please let us know. The other thing that we always like to hear from you is if there's any topics that you'd like us to address in the future, whether it's on employment law, partnership law, any other area of kind of legal kind of expertise. We have that specialty within the firm, and we can always schedule further webinars and training sessions as appropriate. So thank you all very much